Good morning, viewers. Welcome to Consumer Shorthand classes. Ready to start? 5 seconds. Before we take up this question for our decision, we must consider some of the principles to be governed for allowing an amendment of the pleadings. It is well settled by various decisions of this court as well as the high courts in India that courts should be extremely liberal in granting the prayer for amendment of pleadings unless serious injustice or irreparable loss is caused to the other side. In this connection, reference can be made to a decision of the Privy Council in Sweta Roy versus Madhuri AIR 1932 PC 249, in which the Privy Council observed all rules of courts are nothing but provisions intended to secure the proper administration of justice, and it is therefore essential that they should be made to serve and be subordinate to that purpose, so that full powers of amendment must be enjoyed and should always be liberally exercised, but nonetheless no power has yet been given to enable one distinct cause of action to be substituted for another, nor to change by means of amendment the subject matter of the suit. Keeping this principle in mind, let us now consider the provisions relating to amendment of pleadings. Order 6, Rule 17 of the Code of Civil Procedure deals with amendment of pleadings, which provides that the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such a manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. A bare perusal of this provision, it is clear that the Order 6, Rule 17 of the Code of Civil Procedure consists of two parts. The first part is that the court may, at any stage of the proceedings, allow either party to amend his pleadings, and the second part is that such amendment shall be made for the purpose of determining the real controversies raised between the parties. Therefore, in view of the provisions made under Order 6, Rule 17 of the CPC, it cannot be doubted that wide power and unfettered discretion has been conferred on the court to allow amendment of the pleadings to a party in such manner and on such terms as it appears to the court just and proper. While dealing with the prayer for amendment, it would also be necessary to keep in mind that the court shall allow amendment of pleadings if it finds that delay in disposal of suit can be avoided and that the suit can be disposed of expeditiously. By the Code of Civil Procedure Amendment Act 2002, a proviso has been added to Order 6, Rule 17, which restricts the courts from permitting an amendment to be allowed in the pleadings either of the parties if at the time of filing an application for amendment the trial has already commenced. However, court may allow amendment if it is satisfied that, in spite of due diligence, the party could not have raised the matter before the commencement of trial. So far as proviso to Order 6, Rule 17 of the Civil Procedure is concerned, we shall deal with it later. Keeping these principles in our mind, let us now consider whether the High Court as well as the trial court had erred in rejecting the application for amendment of the written statement filed by the appellants. A bare perusal of the order rejecting the application for amendment of the written statement indicates that while rejecting the application for amendment of the written statement, the High Court as well as the trial court based their decisions mainly on three grounds. The first ground was that since the appellants had made certain admissions in the written statement, its amendment cannot be allowed, permitting the appellants to withdraw their admission made in the same. Secondly, the question of limitation cannot be allowed to be raised by way of an amendment of the written statement. And lastly, inconsistent pleas in written statement cannot also be allowed to be raised by seeking its amendment. So far as the second ground for rejection of the amendment of the written statement is concerned, we do not like to delve in detail in view of the decision of this court in the case of Rajatilak versus Surender and others 2001 SCC 472. In para 6, this court observed if the aforesaid test is applied in the instant case, the amendment sought could not be declined. The dominant purpose of allowing the amendment is to minimize the litigation. The plea that the relief sought by way of amendment was barred by time is arguable in the circumstances of the case, as is evident from the perusal of the amendments made in paras 88 to 8F of the plaint, which were sought to be incorporated by way of amendment. We feel that in the circumstances of the case, the plea of limitation being disputed could be made a subject matter of the issue after allowing the amendment prayed for.